Court did not keep any control over the proceedings anymore. If it is to be done by independent application. Now today, I was thinking aloud that if the Honorable Court
even Mr. Bhattacharya, even after disposal of the appeal by order dated by judgment dated 3rd April 2025, this miscellaneous application was entertained.
Was by the state.
Yes. So then, where is the bar in approaching the Supreme Court for getting appropriate clarification?
We cannot approach.
But at the same time, the hand of this court is tied in view of the time schedule framed by the Supreme Court with a default clause, Mr. Bhattacharya.
My lord, kindly forget that the court is only bound to maintain the time schedule. Kindly think, court here sitting in the constitutional jurisdiction is also would be kind enough to consider
that a rule of law must be must prevail.
Supreme Court other directions. Supreme Court others directions in merit is followed or not. Date is only something which is directive.
But tell me whether this date extension of time can be relaxed.
I am not
because today we are in the mid of July.
Even then.
Now, if I set aside this notification dated 30th May 2025,
need not be set aside.
Then it will lead to extension of time for issuance of notification. Then today the resultant effect would be court has to give a direction upon the recruiting authorities and the state to frame a notification within fortnight or within 1 month. That will not lead to extension of time fixed by the Supreme Court.
Then the obligation would be upon the state and other parties that since this is the order due to, can you extend the time? But fundamental task would be.
So when you are approaching before this court, you approach the Supreme Court for extension of time.
Why should you? I have to first get a view that this is illegal. Supreme Court doesn't have the original jurisdiction to entertain a new notification. My lord is well aware that I cannot straight go Article 32 petition filing a challenge notification. It would not be governed. Therefore, I have to approach the jurisdictional court, and if the jurisdictional court finds that this is illegal, then consequently I can approach the Supreme Court. Now, kindly, my lord, now since this is the order that here also on 13th of April, 17th of April, Supreme Court categorically states you follow recruitment process to that post.
Advertisement for fresh recruitment to be.
Therefore, if those
which paragraph? Clarify that all orders.
Now, will kindly come to me, lord. Advertisement for fresh recruitment to the aforesaid posts. Aforesaid post means, my lord, the 2016 selection. Therefore, if it is confined to 2016 procedure and law, there's no difficulty. Even today, they can issue a notification that this was a mistake. We will follow only 2016 rules and the vacancies.
And if aforesaid posts are clubbed along with the subsequent vacancies, where is the bar in the order?
Because under the rules, recruitment rules, you have to.
And how this can be restricted to the candidates of 2016?
Because
that will in contravention of Article 16.
Not at all.
It's a public employment.
Well, the public employment for the vacancies declared. This is not a new process. This arises because of intervention of the court. Had the court not declared the selection was over, then these new vacancies wouldn't have come. Kindly consider this.
But nowhere Division Bench and Supreme Court has said, Mr. Nowhere, that this selection process has to be conducted in terms of 2016 SLST rules of 2016, and it would be confined to the vacancies.
That I will then again.
Nowhere it has been observed.
I invite your lordship to read the judgment in its entirety. Now, what was the issue before the court? Can you excuse me without repetition? That 2000 selection is bad.
Yes.
Now court finds 2000 selection is bad. Now court says do it afresh to those posts. Therefore, the rights of the parties which were there accrued at 2016 would be considered. The subsequent rights would never be considered because these vacancies were there in 2016. Categorically, High Court and Division Bench and Supreme Court says to those posts. Therefore, if it is confined to those posts, it will be confined to the persons who were then eligible. Otherwise, if 2016 election was not set aside, the subsequent vacancies, subsequent rules wouldn't have come into operation to tag with this, couldn't have been. Therefore, reasonable and logical conclusion is that you have to hold afresh for 2016. Do it. We do not say that you cannot hold the examination.
So therefore, your sum and substance of your submission, Mr. Bhattacharya, is this first. These vacancies of 2016, 9, 10, 11, 12 are to be treated separately. And for filling up those posts, this separate selection process is to be conducted following 2016 rules.
That's the judgment, number one. And number two, kindly will again come back to the impugn notification. The notification is still inherently bad. And the Supreme Court, my lord, makes it very categorical that the tainted candidates would be barred.
Yes,
Prohibition.
that's true.
And you have allowed everybody to participate. Number one. Now, kindly consider the notice is irrelevantly bad. Now, the kindly, my lord,
Now, notification, I would ask Mr. Bandyopadhyay two things. First of all, where is the prohibition prohibiting the tainted candidates to participate? There is no such prohibition. And another thing, I would ask Mr. Bandyopadhyay to clarify that if you come to the mark provision
yes,
relating to allotment of
that
marks,
I was going to show.
now they are
Inherently bad. You are
that
creating
is
a class among
also. এই আমার এই ইয়েটা কোথায় ওই লাস্ট ইয়েটা দাও তো ওখানে নোট করা আছে
Oh, you have come ready. That's good. Level the marks.
First of all, there is no express prohibition prohibiting the tainted candidates to participate. That you will, I know you will take this point. And the second is
Distribution of marks.
Distribution
How
of
could
marks.
the additional marks for teachers comes. Thereby, you want to give benefit to those who have been declared null and void by the Supreme Court. Distribution of marks. But that will also get lot in the rules.
Yes, that is in the rule. It is there. Yes.
Schedule 2. At page 110.
This prior teaching experience,
Yes.
whether 10 marks can be allotted,
Yes.
who has lost their job with the finding that there is egregious fraud. So how this can be reconciled?
And then again, if it is about the open recruitment for fresh recruitment.
10 marks for experience. Now, if a teacher who has rendered job in connection with 2016 SLST 9, 10, 11, and 12, how they will get
That
the
is-
marks?
You have correctly marked this. And then again, the distribution of marks was also changed
That I've seen.
to create another door for corruption. I use this expression with all restraint. Now you have seen these rules. Kindly come to this notification, which is under challenge, is of dated 30th May. And
Is there in the notification any provision that the tainted candidates should
No,
not be?
And this rule is published on 29th of May 2025. 29th May 2025 is the rule. And
30th May is the notification.
And there you say that we have additional vacancy in terms of 2025 rules. How could you arrive at the vacancy? If the rule was published on 29th of May and rule gives the detailed procedure for ascertainment of vacancies, how could you on the next day get the vacancies?
But I do not, Mr. Bhattacharya, find fault with clubbing of vacancies along with subsequent vacancies. If those vacancies are included, matter ends. But the question is, where is the embargo
When the vacancies included, you are
clamped upon the untainted candidate, tainted candidates?
So that is one part you have already taken note of. When you are adding the new vacancies, you are inviting fresh candidates. Now that you see the classification is so irrational. When you say that I add these additional vacancies, then you are inviting the fresh candidates who would be eligible today, and they will be putting in competition with the 2016 candidates.
Yes.
Is that fair? Apart from the question of distribution of marks, would that be fair? And when the Supreme Court and High Court says those vacancies only, because this is a fresh test of the persons who had participated. Today, they are thrown out. One group is completely banned, but another group is permitted that you participate and prove your worth. And if